Hello, everyone. Welcome to today's webinar regarding preventing and fixing problems with real estate documents. My name is Brittany McKnight. I'm a member of the State Bar of South Dakota, and I work with Dakota Homestead Title Insurance Company as corporate counsel. Before we get started, I'd like to go over a few items so you know how to participate in today's event. First, I'd like to give a PSA on lawyers concerned for lawyers. Do you or a lawyer or a law student you know have a drug or alcohol problem or are struggling with depression or anxiety? Lawyers Concerned for Lawyers is a confidential independent resource for South Dakota lawyers, law students, and their families. Your referral or visit with LCL is strictly confidential and privileged. Call Becky Porter for more information at 605-391-5191. Becky is an LCL member and your communications with her are likewise confidential and privileged. Today's presentation will last approximately 1 hour. You'll have the opportunity to submit text questions to today's presenter by typing your questions into the questions pane of the control panel. You may send in your questions at any time during the presentation. We will collect these and address them during the Q&A session at the end of today's presentation. Thank you to the State Bar of South Dakota for their support of today's program. I would now like to introduce our presenter, Eric Hansen. Eric works as the president of Dakota Homestead Title Insurance Company. And as I said, he's going to be talking to us today about fixing and preventing issues with real estate documents. So with that, I'd like to hand it over to Eric to begin our presentation.
Thank you, Brittany. Today's presentation is going to focus on just a variety of issues that we come across either in the title insurance realm because of agents submitting questions or situations they've come across, or that attorneys submit saying, I've got a problem, how can I go about trying to fix or address it? A key thing for us to focus on is the understanding of, are we dealing with a material issue or an immaterial issue? This really guides a lot of the consideration as it relates to real estate. A material issue is something that can only be cured by actually correcting the record with a new document in connection with it. It's something that requires the parties that are involved to go through and to fix it. It cannot be fixed by a third party, just one side to a transaction or others. So typically, we're almost always going to be dealing with material defects. The reason for that, as the slide shows, what's an immaterial defect? It's something that's going to cure itself either by the passage of time or that it could be cured by an affidavit or some other recording in the record, not requiring the re-execution, re-acknowledgement, and re-recording by all relevant parties. In South Dakota, we have very few things that are considered immaterial if it's probably going to be rise to a level of a defect for us to care about. So those are affidavits that cure identity. We don't know if Eric Hansen, Eric C. Hansen are one and the same person. So an affidavit could cure that. Address whether it was homestead property by the grantor, that's authorized as an affidavit fix. Same with the marital status, if it was missing on a deed or a mortgage, that can be put of record by an affidavit. Ambiguous recitals for immaterial things. Let's say it has a property address and they put 123 instead of 132. You can fix that with an affidavit. Then find the marketable title affidavits. That's the affidavit of possession that goes along. That's going to cure old defects more than 23 years old since the last deed of record along the way. All right. So again, everything we're going to be talking about from this point going forward is going to focus on material defects and how to go about fixing them. Because if it's immaterial, we can usually fix it right away just by putting something in the record. All right, let's start with deeds. First and foremost, the most common issue that we run into when it comes to deeds is the incorrect signature and especially acknowledgement block whenever we're dealing with anyone other than individuals. All right, now, it's great that there's a default acknowledgement that most instruments have, most forms have on there, but it's very important to work on lining up the specific acknowledgement block that's necessary with the actual grantor, mortgage, or whoever is going to be signing along the way. All right. A common example that we run into is that the last document that was maybe prepared of that same document type, uses the same acknowledgement block going forward when it needed to be changed or updated. The same applies when it comes to if you're using like Laserdisc or other lender specifically generated forms, that it may not have the correct acknowledgement block format that goes in with it. First, this is an issue because it's something that's checked on that post-closing review, whether it's by the title company, the lender that was involved in financing the transaction, hopefully not, but potentially bankruptcy trustees along the way too. They're reviewing those to make sure, does this match? And the most common situation we run into is it's going to say Eric Hansen, a married person, appeared before me. Well, let's say I was signing on behalf of Dakota Homestead, and it should have established that Eric Hansen, as president of Dakota Homestead, appeared before me and in such capacity as president executed the documents on behalf of Dakota Homestead. So it's really important to make sure that that acknowledgement block matches the actual entity or the grantor that's involved along the way. Title 18 of the South Dakota Code, specifically 4 and 5 in there, has a lot of different acknowledgement block samples that go with it. If you ever run into an issue though, Brittany, Chris Moran, and myself, we've done up a list of acknowledgement types for different entities that we freely share with others, just because trying to address that issue becomes a big problem later on. What is that problem? I mentioned a little before, hopefully not a bankruptcy trustee taking a look. The reason for that, a document that fails or has a defective acknowledgement fails to impart constructive notice to third parties for 10 years from the date of recording till it's cured by the passage of time. All right. What that means is unless someone has actual notice of the transaction of that recorded instrument, everybody else can ignore it as if it didn't exist in the land record, all because the acknowledgement was bad along the way. It's important to note that typically when a register of deeds is reviewing documents for recording, they're just checking, does it have an acknowledgement block? They're not going through and checking, does it provide the correct acknowledgement block to actually provide constructive notice in terms of compliance with the statute. All right. That's why we really want to make sure that any documents that you're involved with, you're always double checking those acknowledgements that are along with it for any deeds, mortgages, or others. All right. All right, this one comes in where we have requests after the fact. Let's say we have a trust, dissolved entity along the way. How do we clean up the record? Because that entity no longer is around, that trust isn't there anymore, but they're still showing up as the record title owner, typically because somebody forgot to do a deed transferring ownership at some point in the past. While each situation is different, you have to consult with the title company and they have to consult their underwriter for specifics. The easiest way to think about handling these omitted pieces of property when it comes to previously dissolved trusts that are no longer in existence is treat it like a business entity. We're not caring about actual good, valid title. We're cleaning up the legal title along the way for that record title, all right? Because of that, oftentimes the title company is just looking to see, do we have a deed? So can we find who the prior trustee was? Can they give a quick claim deed, transferring ownership, terminating that record interest that exists out there that's still clogging up the record? We're going to want to make sure that whatever is done is okay and approved by the title company along the way. But this is very much the case where we're trying to just cure a defect in the record rather than actually do a legal transfer of title, because typically someone else through some other source has already taken ownership of that property. All right, to be platted, parcels, tracts, all of it. Big problems in terms of how these things come about. The first one, parcels, tracts, things like that. For those listening, and I'm sure for now or later on for the recording, if you've ever been involved with a real estate transaction where there's multiple pieces of real estate, sometimes from different owners, all being involved and showing up on a title commitment, you may see a designation saying parcel 1, legal description listed behind, parcel 2, legal description listed behind that. The reason for that is that the title company is using that designation so when they get to Schedule B later on and they're listing requirements and exceptions, they can quickly reference and say, as to parcel 1, we show the following mortgages need to be released of record, and we show that the easement needed to be recorded. Then they go down and they list everything for parcel 2 along the way. It's an identifying piece of information that exists for the title company on their commitment or their final title policy that's not typically part of the legal description. Why I emphasize that is that oftentimes It's habit, right? You receive a title commitment to prepare a deed, you copy that legal description on there, and what do we start seeing? We start seeing parcel one, tract one, things like that ending up in the deed and the mortgage, now making it seemingly part of the legal description, leading to questions in the future. Somebody saying, what the heck does parcel one refer to when there's a separate deed, or things like that. If you ever have a question and you wonder, is this actually part of the legal description, ask the title company. They can let you know right away. So that way, when you prepare that deed or that mortgage, you're using the correct legal description rather than including some separate identifier along the way with it. All right. We have the separate issue though too of making sure that everybody signs all documents. And this is where we come up with the to be platted or related property. Anytime we're dealing with, platting of property, all parties that have an interest in the property should be joining in on that plat. First, I know that this is a, more ridiculous statement and comment because I've talked about this at past CLE educationals. How often do we see the actual mortgagee for the lender signing a plat? How often do we see an easement holder that existed prior in record signing? It never happens. But just to be aware, if you want to make sure that you don't have the risk of that plat being taken out, foreclosed, disregarded by someone whose interest appears ahead prior in time to that plat, they need to be joining in and signing off on the approval process for that platting process. The bigger problem is other people being missed who have an ownership interest in the property not signing off, or the incorrect entity, back to that same slide we talked about before, not signing that plat. Make sure that if you're involved or helping your clients with any platting decisions, that you get an updated title search or you contact the title company to confirm things. We see common problems where relying upon the tax record or what your client tells you the ownership is leads to situations where we don't have the correct entity involved who's signing that plat. Also important along the way to make sure that they've all taken care of signing in the correct capacity. Again, make sure they sign, they're the trust, they sign as trustee, not as individuals when it comes to ownership. Okay, now we talked about beforehand. Hopefully that's everything done, but what happens if you didn't catch it? And we find out later on that we needed to fix the defective plat. While there is a surveyor's affidavit that allows for some fixes, having the incorrect owner sign the plat is a material issue that typically, one, should require actually replatting the property. Nobody likes that answer. Instead, you may be able to get away with an owner's ratification, all right? So that's where something similar to the original owner's certificate is signed, stating that this plat was previously recorded here, that so-and-so was the owner of the property, that they inadvertently, by mistake, were left off a site, but that they certify and agree to that platting and gets recorded in the land record as if they had signed the original plat. Finally, always remember you can include additional information in any recorded document that you're dealing with. So let's say that you're dealing with some property that's not yet platted and you're going to reference the easement that's going to show up along the way, or that it's going to be known as this. Put those additional details in there. So that way there's no confusion later on where maybe things get recorded in the wrong order or on different dates that leads to a question about whether or not we were dealing with the same property, or was the easement at issue validly created. All right, we talked in general more about deeds and references to documents. Now let's talk a little bit more specifically about mortgages. Same issues we already kind of discussed, making sure we have the correct entity. Do they need to join in on a plat? So the other part is making sure that every recorded document contains the same or correct legal description. We've run into situations where somebody has prepared a deed well ahead of time. Maybe there's a plat, maybe there's an update that they added or removed property. It creates confusion later on when, let's say that it's the same transaction, but one document has this for the legal description and one document has, instead X has Y. So make sure that you're reviewing those and confirming with the parties. As the attorney, who's probably going to be kind of more the coordinator for some of the aspects of a transaction, it's always good to ask to review a copy of all documents before they're signed. Usually the title company, the lender, anyone else involved will be able to provide those to you. So you can give it a once over, double check those legal descriptions, make sure that everything lines up along the way. Okay, other issue with related to mortgages is releases. When it comes, I'm not going to get into details about the world of, mainstream lending, secondary market transfers, getting correct releases from entities along the way there, because that's just a whole separate problem in our business. We often, though, will see problems with private mortgages, those that are done along the way where a mortgage still remains and hasn't been released, and maybe one, both, or however many of the mortgagees no longer are around. All right. First, anytime we're dealing with a mortgage, the title standard 1405 requires at least only one of the mortgagees has to execute a release for it to be valid and proper. So in a situation, let's say where mom and dad lent money to a child, they actually got a mortgage to secure that interest out there. They go ahead, maybe dad's dead, mom is still around, mom can still release that mortgage, even though not all of the original mortgagees are around. That also is related to, let's say that both mom and dad have passed away. As long as they have an estate started for one of them and a PR appointed, doesn't have to be completed, but a PR appointed, they can go ahead and execute that release, allowing that mortgage to be released of record. The other issue is that typically if a title company is involved in the closing and there's been some delay or some issue with it, as long as the title company has a payoff statement and they match that up with the actual payment that was made as part of the closing, pursuant to SDCL 44831, the title company can do a title company release to take that and get it taken care of. Oftentimes on private mortgages, that's not going to be applicable because usually it's something that was paid well outside of closing over the course of dealing between those private parties over the years. But just in case that sometimes comes up, that might be an answer too. Big takeaway on that is making sure as long as we get a release from a mortgagee or their personal representative, guardian, conservator, whoever is taken involved along the way with it, we should be good and able to transfer and clean that up in the record when it comes to unreleased mortgages still that are around. Okay, non-merger deeds, subsequent satisfactions, deeds in lieu of foreclosure. This is one that, hopefully things continue to go in a great direction when it comes to the ag economy in the state and others. So we don't see a spike, but it's always good to be prepared to deal with alternative versions to judicial foreclosures. All right, there's three primary ways to foreclose real estate in South Dakota. The first is a judicial foreclosure. All right, so that's what's authorized under 2148A of the code. That's what we typically think about, where there's a court action started, notice sent out, a judgment of foreclosure, typically after a default judgment is entered along the way, that then converts over to a sheriff's sale, a right of redemption period, so on. All right. The other two ways are, one, a non-judicial voluntary foreclosure. All right. That exists in statute. That's 2149A, I believe, for that location. The non-judicial voluntary foreclosure works where you have the agreement between the borrowers and the lender, and they agree to follow a statutory process that allows them to deed the property over to the lender provide notice to in the form of personal service to the junior lien holders who have a right of redemption if they so choose, and then after that process is done and no one redeems, they can go ahead and take ownership of the property free and clear of those junior lien holder interests out there. All right. Again, non-judicial voluntary foreclosure, a statutory situation that's authorized that cleans out those junior interest holders. Compare that, though, to the deed in lieu of foreclosure, which is a non-statutory approach that's developed as a practical way around foreclosures as time has gone on. In a deed in lieu of foreclosure situation, the borrowers are just deeding the property directly over to the mortgagee, such that they're taking subject to any junior interest holders that are out there. No different than if they had deeded the property to some other individual. All right. In both the deed in lieu of foreclosure and the non-judicial voluntary foreclosure, a key term that usually shows up in those documents is what's known as non-merger deeds or non-merger language. As our understanding in common law that's continued on, if we have a lesser interest in real property and it goes over to someone with a greater interest in real property, that causes a merger of those estates and real property into that greater estate that was there before. So in this particular case, if you had a mortgage interest along the way and then you got fee simple title, that mortgage interest is extinguished. It goes away, it merges as part of that greater fee simple interest. So that causes that lien to lapse, unless you include non-merger language, which is what's typically done. That non-merger language is included such that it's giving the lender the option, really, of, let's say that they maybe find out later on that they don't want to use a non-judicial voluntary foreclosure or a deed in lieu of foreclosure. They can still go back and then judicially foreclose under their existing interest in real property. The issue with that is that what happens post transaction when that lender is now going to be selling the property, if they haven't released that existing lien, that mortgage that was at the heart of that foreclosure, then it's still going to show of record, needs to be released later on. It hasn't automatically merged or been terminated because of either the deed in lieu of foreclosure or a non-judicial voluntary foreclosure. So it's really important to make sure that if you're taking advantage of either of those options and you include non-merger language, then you need to make sure and plan on actually releasing that existing lien at some point prior to that transfer of the property. As a reminder for the deed in lieu, remember those junior lien holders, they still have priority, so it's important to usually get a title search prior to accepting a deed in lieu of foreclosure to see what, if anything, might actually be ahead of the lender if they accept a deed in lieu of foreclosure. And not listed on here, but just a practical matter, make sure that they're completing along the way estoppel affidavits or other similar documents that are establishing the relative value that the borrower had in the property, and that they are informed and had the advice that they could receive counsel to before they did that transfer. What you want to avoid is potential claims later on arguing that the borrower was forced into, coerced, had no choice but to do this deed in lieu of foreclosure along the way. That's where that estoppel affidavit puts that in the record and is something that prevents, and gives reliance on third parties so they can rely upon that with confidence, so they know that this was an okay transfer that's not going to be subject to later on claims or attacks by those borrowers. All right, let's get into the divorce context and issues associated with it. First issue deals with anytime we have a money judgment. So that's a set dollar amount that's due, not like an alimony, child support that's going to be a periodic payment over a period of time. That personal amount, that money judgment amount, is going to be a lien on the property once that it's docketed in the county where the case is going on. All right. How does that happen? You go in, you work on getting your divorce settlement agreement along the way. You've got your divorce decree, and it maybe provides in there that, for my wife and I, we're separating, and we have in there that says that I have to make a payment of $75,000 to Beth Hansen. All right. Once that divorce decree is done, finalized, and entered into by the court, that's now become a $75,000 lien against all property that I own in that county. So let's say it was in Minnehaha County here in Sioux Falls. Now that encumbers not only any property I currently own, but any property I acquire at any point along the way in the future. Now, typically, it's only docketed in the county where that case started at, but it is possible, just like any other money judgment, to transcribe that lien into other counties in South Dakota, so it applies as a lien against the debtor's property in those locations as well. I wish this was an easier one, but the fact is this is a tough question in most divorces, because let's say we have a situation where instead of saying it's immediately due, let's say that maybe we're giving the spouses time to refinance, and it says like 6 months from now there has to be a $100,000 equalization payment due by this date. Generally speaking, the title company is going to treat anytime they see a dollar amount due in short order or due at a specific time as a judgment, even if that wasn't the intention of the parties, to avoid it being a potential issue or argued later on that it was something that had priority over the transaction issue. If you think that you may have a situation Please feel free when your client is going ahead and refinancing, selling property, to let the title company know, yep, we're aware of that divorce decree. We know what that is. It's not a judgment, and you can CC the other counsel on that email along the way, or maybe say that it is and that you're expecting payoff in connection with it. All right. It's important to make sure that those are questions that could come up, because you may be receiving a call from a title company or someone like myself saying, hey, I've just reviewed this file. I see in here for Eric's divorce that shows that there's this judgment, that's this payment that's due at some point in the future. Can you tell me, was this supposed to be a lien or not against the property, so we know what we need to show or not show when we're putting together that title commitment? All right. Other big issue with divorces is conveying property that was supposed to go to one spouse or the other pursuant to the divorce decree. All right. The real property division is often an essential part of going through or resolving any divorce along the way. Where this comes up is the following situation. All right. It says in the divorce decree that Beth Hanson is to receive property. First issue that goes along with it: how are you describing that property? What I specifically mean is, typically a lot of divorce decrees, especially those done by the parties on their own, are using street addresses only to convey legal descriptions, rather than the actual legal description of the property that should be listed along the way. That can lead to ambiguity to know what particular piece of property, because sometimes we may have multiple legal descriptions associated with one street address in connection with it, or that street address may not even match up with the legal description they were thinking about because of a mistake or something else along the way, leading to this question mark of whether or not the divorce decree is actually being complied with. My advice is for any attorneys, if you ever think or have a question about, what exactly is that legal description, please feel free to contact your local title company. They're usually willing to, it may not be an immediate answer, but they may be willing to just give you that answer saying, yep, here's what I show for the last deed of record. So you can put that and include the accurate information in when you're filling that out and complete it, so there's no confusion later on. All right. Let's get into the more practical part that goes in with it, which is, how do you do that transfer? Because as somebody who's had to be involved in talking to separated spouses years after the fact, nobody likes it when they're contacted about needing to get a quitclaim deed from them or some other transfer for property that they didn't receive in a divorce, but that they still had an interest in that needed to be terminated. My practice advice tip has been for years, if possible, please include a provision in the divorce decree that allows for it to be used as the conveying instrument to be recorded in the land record after a certain date or period of time. It's oftentimes easier to just take a certified copy of that divorce decree and record in the land record as the transfer instrument to terminate an interest, rather than trying to find a former spouse years after the fact to see where they're at and then get them to practically execute a deed to terminate interest because there wasn't done timely in connection with it. The other practice advice that goes in is, anytime you're dealing with a divorce, it's okay, like I said before, to put additional information. It's okay on that quitclaim deed from one spouse back to the other to say, done in fulfillment of, and then put the divorce case number in there too. So there's no confusion about what it was for. There's no harm in annotating your record instruments to add those additional information beyond the bare minimum requirements that exist. The last part on divorce decrees is, if you're going to have a client that maybe had an interest in the property that needs to be conveyed, do it right away. Don't put it off along the way in with it. We don't need to receive deeds if all a person had was a homestead interest. That terminates once that bond of marriage has been severed by the divorce decree. But what we often see is property was owned, husband and wife, either tenants in common, joint tenants. Only one of them gets the property. There's never a deed terminating that other spouse, that non-owner spouse, non-occupier spouse interest in the property. So it causes a problem for us going forward in terms of what happens. Last part on divorces is, and not on the slide, but you've heard me talk about it before, homestead issues associated with it. Up until the time of that divorce decree being entered, the couple is considered married under South Dakota law. That means that one or both of them can be deemed to have a homestead interest potentially in the other person's property even if they don't intend to reside there. All right. South Dakota doesn't have a purchase money mortgage really exception that exists for mortgages that would allow for a single person or a married person who's separate to buy property without consideration for their spouse. So we require that the mortgage, not the note that guarantees the debt, the mortgage, the security instrument that's encumbering the property, that as long as a person is still married, has to be signed by both spouses if it's going to be the homestead property for one of the spouses. They don't have to sign at the same time, but they do have to join into that, because otherwise, under the homestead statute, that potential deed, or more applicable in this case, mortgage, could be deemed to be void because it wasn't joined by all of the spouse and other members of their family who have a right to potentially void that under the homestead statute. Okay, let's talk about a few other issues that come up in the real estate context. First is when you're reviewing the title commitments from an office. On there, always check the effective date. That's going to be on Schedule A along the way, all right? That effective date's really important because it's saying that we're disclosing anything of record prior to that point in time, which implies that we're not disclosing a title commitment, anything that comes after that effective date time period, all right? Anything that's in that time period from the effective date through the closing recording date of your instrument is what we call in the industry the gap period, okay? Now, while there may be gap searches, the lender may require that we update to make sure there's no issues. It's important to ask your client or to talk to the title company if you want to make sure that there's no potential problems out there. Knocking on wood, we haven't really had as many gap issues in South Dakota as other states have, because there's plenty of times where fraud occurs by taking advantage of that gap time period. A common scheme that we saw prior to the real estate collapse in 2008 and 2009 was you agree that you're going to be selling your house, you get a title commitment in connection with it, and some unscrupulous third-party lender gets involved and then lends you money and records that mortgage in that gap period, kind of like a second or a home equity line of credit. They put that in there. The title company, the parties don't do an update search during that gap time period. It closes. Next thing you know, that gap mortgage that nobody thought to check for now is in first position ahead of the new owners, ahead of the new lender that's involved, and they demand payment along the way because they're in the superior position and they're going to foreclose unless you pay. Now, thankfully, we haven't seen that as much here, but it's important to be aware of that. So if you're helping advise your client, make sure they're getting an update prior to closing to make sure there's no intervening matters that have been recorded between that effective date of the initial commitment and the actual date of closing. Another thing you may see on title commitments is maybe on that Schedule A or Schedule B, the street address that's listed, all right? Usually it has a designation that says for informational purposes only, as shown in the tax records, something along the way there. I talked about it during the divorce portion. We don't care about the street address for title purposes in the real estate world, all right? We're focusing on the legal description. But you may want to know what that is, or the lender may require that for some reason. If you have a question about what that street address, if you think it's right, wrong, or otherwise, please let the title company know. Most common situation we see with that street address is new construction property where maybe everyone thought it was going to be a particular address, but by the time they actually put the house up and everything else, it has a different mailing address because that wasn't available yet at that time. So that may cause a disagreement where they're saying, well, I thought I purchased, 246, not 248 on this property, and that's not what I actually received. Again, you probably did receive the correct legal description for the property at issue, but street address confusion can create problems. We talked about the parcel A1, 2, tract 1, tract 2 portion earlier in connection with it. Just make sure you know, is something that's included on that legal description part of the commitment, is it actually part of the legal description or being included for a reference purpose only along the way? Okay, remote notarization. This is a topic that I have talked about frequently. It's not one of my favorite ones, but it is one that's really important to go through. First, I would say that if anybody wants to hear, me talk for an hour going through this, there's a state bar presentation last November, and I'll be talking about it again this summer at the annual convention, because it's really important that we work on addressing and figuring out the long-term approach to remote notarization in South Dakota. Currently, during this legislative session, Senate Bill 193, specifically 193C, is what passed the Senate Judiciary Committee this morning, provides some additional clarification out there on it in terms of what to do when you're using remote notarization. All right. Big caution point for anyone listening or viewing later. Be aware, just because South Dakota does have a form of remote notarization does not guarantee that real estate transactions where remote notarization is used are going to be insurable without exception by a title company and by a title insurance underwriter. There's some specific concerns, issues that could arise. So if you plan on using remote notarization for a real estate transaction, please contact the applicable local title company so they can make a determination, or more likely turn it over to their underwriter to make a determination as to whether or not they're going to raise an objection to what was done and included. Drainage rights, recorded documents, covenants, restrictions. If you've ever spent time flipping through title insurance commitment, you may see a bunch of recorded instruments listed as exceptions on Schedule B in there. Why is that? Because anything that's been recorded against the property that hasn't been released, or that's not listed as something that can be ignored under the title standards for abstractors, gets shown as an exception. Now, does it actually have priority? Is it actually effective? Are typically questions that can't be answered on a title insurance side, similar to how an abstractor couldn't answer them, and maybe an attorney on an attorney's opinion could. All right. The default practice in the title insurance industry is if something's been recorded, it shows up as an exception along the way, because we just don't want to have any potential claims or issues arising out of it. If you think there's ever a situation where something isn't applicable, you can always contact the title company or the underwriter to get further guidance. All right. Here's a couple examples of those types of documents. The first is vestige drainage rights, or drainage rights, drainage conditions, drainage easements. Pick your words that you want to go along with it. There is a lengthy history of how drainage rights were dealt with in South Dakota prior to the adoption of SDCL 46A10A in 1985. There's actually a great summary put together by the AG's office that goes through that history, goes through the issues and the processes. You can let me know, I can certainly send out a copy of it. What was happening was there would be all sorts of drainage rights that'd be recorded, where I just go ahead as a farmer, as an ag producer, and say I have drainage rights over the following property, both my own and maybe even adjacent neighbors. All right. Was it legally effective? Probably not. In part because typically the other owner of the property that was subject to those drainage rights didn't sign it. They weren't a party to that agreement. The other thing that we had happen is from 1985, when the new statutory scheme was adopted, I would say up until the early 1990s, compliance with that scheme was spotty at times, where some people were still using the old approach to deal with drainage rights. In modern times, I'd say the last 20 plus years, it's been pretty good for following the statutes. I haven't seen too many recent ones that are questionable that goes along the way with it. All right. The simple answer is, short of complying with 46A10A, drainage rights typically are not going to be effective. But because they recorded in the land record, the title company is still going to take exception to them, just in case there's any issues that arise along the way. Same approach applies to covenants and restrictions. All right. Now, we're starting to hit the point where developments that were done in the late 80s, early 1990s, into the early 2000s are starting to reach what would have been the expiration point for the covenant restriction time period. It's a tough issue, because most of those covenants and restrictions for private zoning include in their language, it says, well, they automatically renew. All right, that it continues on for effectiveness after this period of time. It's questionable if that actually works or not. So SDCL 1154, which deals with first and second class municipalities, said that there is a 25-year limitation for how long a restrictive covenant or restriction can remain in place. Now, House Bill 1084 seeks to change it. The amended version of that has it proposed as a 40-year time period, so it's good for 40 years. We can debate and discuss whether or not that's retroactively applied. That only applies to covenants and restrictions adopted after July 1st of this year, because that's an open question that'll have to be gone through. But the short answer is a title company, without seeing a release for those covenants or restrictions, is going to list them as an exception for their purposes when they're putting together a commitment, even though it may not be applicable. So it's important to know that, because it may be the case where even though it's shown as an exception, and maybe your client wants to change the siding on their house, put up a chain link fence instead of having to put up a vinyl fence, they may still be able to do so, but it's not going to be specifically authorized under the terms of the title commitment or the policy, just because we don't want to wade into that fight for determining the effectiveness of it. But we certainly can provide copies of those documents if you're looking for them. H lots, highway lots. This is an area that causes problems because of, one, the statutory scheme that was used when it came to platting H lots along the way, and two, how the exclusion of H lots can impact property both now and long into the future. All right. So starting point is H lots are typically going to be platted as their own separate piece of property because it's for highway purposes, even though the only thing that's being conveyed is usually an easement over to the Department of Transportation. Starting about 1965, there's a difference in terms of approach for how things are done. The highway will usually, the Department of Transportation will usually acquire fee simple to maybe the actual underlying roadway, but for the area offset along the side of the road in terms of our ditches and everything else, usually that may be in each lot for easement purposes only. What happens though is that the surveyor goes about and creates that each lot, records that, and then that leads to this question. All right, let's say that I own the southwest quarter, and in the southwest quarter of the property, there was 2 or 3 H lots that were along a public road beside my property. All right. Whether because of a prior deed or a title commitment, something along the way has maybe included a phrase, the southeast quarter, less than accept H lots 1 through 3. All right. But remember, there was only an easement that was given. So what happens if they ever release those H lots in the future? Question mark at that point. Specifically, when we're dealing with H lots, there's going to be a point in time where we're going to have to deal with the reckoning of this excluded property that hasn't been conveyed. Does it still remain in that original owner prior to that exception that was in that deed? Or as a matter of public policy, has that property been conveyed, transferred along with it? So that way, once the H lot's terminated, does it go back to the adjacent owner, similar to how it works for rights of way, where it goes to the adjacent property owners as a matter of default if it's ever vacated. All right. This is another area where we may exclude in the legal description for a commitment in each lot, just so you don't have to raise as a separate exception in the rest of the title commitment. But for you and your clients, it may be fine to actually convey the full property, including the H lots in the deed, if you want to make sure that there's still this continued chain of title passing ownership. It's just subject to that H lot along the way. There's not going to be an easy answer when it comes to H lots. They're a complicated situation that's on a fact-by-fact, case-by-case basis to determine what's the best way to handle them. But it's important to be aware of the potential long-term implications associated with them, because we may start running into situations if there ever is a vacation or a termination of those easements that underlie the H lots, about who is the owner of the property and what needs to be done to fix it along the way. Okay, talked a little bit about plats and surveyor affidavits before. The first part was already covered, the incorrect party, when we talked about making sure we have the right person, right entity along the way that goes in with it. Second issue is proposed easements in plats prior to their existence, or when we have, the same common ownership of the dominant and surveying estates. All right. So somebody decides to plat out property. Let's say that maybe I own some lots along the Missouri River or by Pickstown, okay? Along the way, I go ahead and I set things up, and I, as the owner, draw up my master development plan along the way. And either because I choose to leave it as a private roadway, or the more likely situation where the township, the county, the municipality refuses to allow it to be a public road because they don't want to handle the maintenance and upkeep of that roadway, it shows that this is a private easement that exists to provide access to all those pieces of property. All right. We talked before about the concept of merger. I cannot create, well, I still own the dominant, property along the way. I can't create a servient interest on my same property that will allow for an easement to myself. So the proper way to address this, you can still show it in the original plat, but each time you transfer ownership to someone else, that first time we have a difference in ownership between the dominant and the serving estate, then I should be including language in there that says, in addition to that easement as described in that previous recorded plat, include that information. Or I could record a separate easement agreement later on to those parties. What happens? Typically not that. What typically happens is that the deeds are all done, and we find out later on that, oh, by the way, this private easement was never validly created. Now they may be looking for the homeowners to do some improvements on that roadway, and now they need to get everybody who has an ownership interest to basically agree to what was in that original plat. So it's really important to make sure that as you're advising your clients, you're reviewing, do they actually have legal access to the property? And then two, if there's any purported private drives, easements, other things, is it being created each step along the way? In most cases, a little bit of time and review with an attorney before doing those deeds could come up with a standard template format for how to convey that easement in each successive deed, rather than running into the problem where it was ignored and then years later trying to address it. Other issues with plats, if it's an immaterial, back to the beginning of this presentation issue, surveyor's affidavit found in SDCL 43-1811 can be used to fix it. All right, it can fix both errors and omissions that are done in any plat along the way, but it cannot be used to modify the property lines. You can't add or subtract property compared to what was on the previously recorded plat. All right, so typically a surveyor's affidavit is going to be used because maybe we forgot some portion that went along with it, or maybe there was a reference that maybe there was something that happened that the dimensions, the actual shown pins, boundaries was the same, but maybe the typed up legal that went along with it had a typographical error. So it's not adding or changing the dimensions, it remains the same, but needs to be fixed. Just as a reminder, it's only going to be those immaterial issues. You can't use it because, oh, we forgot a whole piece of property that should have been listed on a conservation easement along the way. Okay, on the presentation handout, you should see for the drop down that there's a whole portion on there for the effect of foreign probates when it comes to real property. I'm just going to switch my screen over here. This is likely going to be part of a bigger discussion at some point later on, but it's just important to go through. Only a South Dakota probate court has jurisdiction to administer and deal with the transfer of ownership of any property located in the state of South Dakota. I know everyone jumped on today wanting to have a discussion about subject matter jurisdiction along the way, but that's important because there is no process for doing an ancillary or a foreign probate where some other court can exercise jurisdiction over property in South Dakota. Specifically, what does that mean? It means that if someone dies while owning property in South Dakota, a South Dakota personal representative has to be appointed to deal with the real property located in the state. Specifically, that's explained in Title Standard 1517, as discussed on there, and supported as you go through the probate code. First and foremost, you have to appoint someone for administration subject to the provisions that exist in 29A4. All right, 29A4204 says that if there's no local administration or application in this state, a domiciliary foreign personal representative may file with the court. Great, except right away in 4205, they take that away in connection with it, where it says what powers does that foreign personal representative have in the state. And they have all powers except that no will is effected to prove the transfer of any property admitted to probate in a local proceeding. It could have been certainly worded differently, as the bottom portion lays out on this handout. The short answer is you have to appoint a South Dakota personal representative. Don't have to complete the probate, but you have to appoint one through the application and the proceedings for that South Dakota appointed personal representative to handle, to deal, to transfer anyone along the way for property associated with real estate. All right. Where you're going to see this come up is typically there. I don't know, it's about half a dozen to a dozen times a year we'll get a call saying, well, I've got this ancillary probate part of the code. Why can't I just, record, domicile that in South Dakota? And we send this out and explain it. If we want to do something different, we have to look at specifically 29A4205 to maybe consider removing that limitation, or to discuss that goes along with it, as well as having the bigger discussion regarding subject matter jurisdiction of, is it even possible to transfer that authority that goes along with it to someone else for having the ability to administer real property in a non-South Dakota-based probate. One other document, I'll make sure this gets posted on there. This is a handout that we put together, I think in 2016 for SDLTA, Land Title Association event. Just going through recording corrective instruments. We've talked about fixing problems. I'm going to include this in the materials as well. Key idea, we talked before about material. Anytime you have a material correction that's going on, we mentioned before, you got to re-execute, re-acknowledge, re-record it. If you want to tie it in to fix that prior instrument, it's important to reference what you're correcting, typically by including the recording information previously recorded on such and such book and page. And if you want to explain what's being fixed along the way. What we see happen is sometimes there'll be other deeds that are done, maybe changing the legal description. Well, that doesn't fix that prior one that appears to be valid on its face. Or let's say we record a whole new mortgage. Well, is that tied to the first one? So what happens? Is it satisfied when that second mortgage is satisfied? Is that first one also satisfied? There's title standards specifically addressing or dealing with that issue, as well as this handout that kind of goes through that process and explains what needs to be done in each case, how it should be done, what the references need to be, and what's the best way for dealing with and addressing corrective instruments that are being done to fix issues in the land record. All right. I think I've got about just over 5 minutes left. Brittany, I think we'll just wrap it up and leave it for questions. Please submit anything that you have. I'll stay on as always. If anyone needs anything, you can always reach out to Dakota Homestead. For Chris, Brittany, or myself, we're always willing for discussions. So with that, Brittany, what do we have for any questions during the presentation?
Thank you, Eric, and thank you for that presentation. I did not see any questions that came in through the panel. Unless I'm missing some here. So with that, I think we'll just maybe, okay, I got an update saying there are no questions posted.
Awesome.
But I will say that you can still submit questions by contacting the State Bar. You can email them at info@sdbar.net, and they will get those questions directed our way. I want to point out that once you leave the webinar today, you will receive a survey on the presentation. The State Bar would appreciate if you could complete that and provide your feedback. So with that, again, thank you, Eric, for that very informative presentation. And on behalf of the State Bar of South Dakota, thank you all for joining us, and I hope you have a great rest of your day.
Thank you, everybody.